If I could ask everyone to take their seats, we'll start in about 30 seconds.
It's different with power. Yeah. Yeah.
Welcome, everybody. My name is Kitty Boone. I run the Aspen Ideas Festival. It is really wonderful to have such a great group on the first night. I want to start by thanking Michael Goldberg and the team at Belly Up for giving us several nights this week of their wonderful venue, Casual Conversation. And I think, Michael, if you're here, we're sold out every night, which is really fantastic. And I know it's a little uncomfortable back there, but you'll get over it as soon as you start hearing the conversation. It's my great pleasure to introduce tonight, partly because this is a little bit of an anniversary. We started the Ideas Festival 5 years ago. This is our 6th. And the first night of the Ideas Festival, I had this idea that we should go into town and open up the festival to the public and do things in environments like this. And I got a little bit of pushback from people at the Institute saying, why are we going to a nightclub? And I said, because that's the way you're going to get people to engage and get laid back and not take everything so seriously, perhaps. So what we did was we decided to invite David Boies and Ted Olson to come to Belly Up. And that night, they came to talk about an issue on which they were on opposite sides of the fence. They told our audience about what it was like to deal with Bush v. Gore. Now, we had started the festival with our big session, we had a reception, and all of a sudden, all the electricity in Aspen went out. And this space had one spotlight, no microphones, no air conditioning, and when David and Ted started talking, nobody left, and you could hear a pin drop. And they drank really good red wine, which I'll never forget, and they might tell you a little bit about what they're drinking tonight. But it's just my great pleasure to introduce you Ted Olson and David Boies in conversation with a wonderful friend of the Aspen Institute, who's a brilliant law professor and writer for the New Republic, Jeffrey Rosen, to talk about what they are both on the same side of the aisle about now, which is gay marriage in California. Thank you very much.
Well, welcome, ladies and gentlemen, to this remarkable conversation. We are indeed in for a treat tonight. Imagine having a chance to hear Thurgood Marshall, the leading Democratic lawyer of his day, right after he'd argued Brown versus Board of Education, the great desegregation case in the trial court in 1952 or 53. But of course, tonight we have not only the leading Democratic lawyer of the day, but also the leading Republican lawyer, and we have this incredible spectacle of seeing them both join forces to argue this incredible case. I have to confess, I was just at an event over at the Aspen Institute and watched the Surgeon General of the United States, and she gave a speech and she was a little nervous, she was stumbling and stuff, and she said, I'm sorry, she stopped. She said, I'm not usually nervous about speaking in public, but I just heard something very, very intimidating. Barbara Streisand is in the audience.
That'll do it.
Well, now, we can't quite see through the lights, but we've heard that Barbara Streisand is here again tonight, and that's why I'm going to have a little of Ted and David's excellent red wine so that we can all cool down and prepare for this conversation. You know the biographies of these remarkable men. It's not hyperbole to say that they're the leading Democratic and Republican lawyers of their day. Ted Olson, the former U.S. Solicitor General, former head of the Office of Legal Counsel at the Department of Justice, famous for arguing scores of Supreme Court cases, not only Bush v. Gore, but also the Citizens United case, and universally respected for his devotion to the Constitution, and David Boies, in addition to his work on the other side of Bush v. Gore, was the chief counsel in the Microsoft antitrust case, where he won a heroic precedent and has just been so inspirational on all of these issues. So we're going to have a freewheeling conversation. There's a lot to talk about. And I'm going to begin with the obvious question. When you interview a sort of unusual couple, you ask, how did you meet? The internet, introduced by friends. Ted, I gather you were there was a matchmaker, and you started the whole thing. So tell us the story.
I did in this case, but David and I met a long time ago. Thank you for mentioning all the cases that would make me the most unpopular person in Aspen. But I've gotten on the right side, I think, at least for tonight. But David and I both worked for one of the famous New York law firms. It's interesting, David's career started as a summer associate at Gibson, Dunn & Crutcher in Los Angeles, and mine as a summer associate at Cravath, Swaine & Moore in New York City. And then I went to work at Gibson, Dunn, and David went to work at Cravath. But we got together again in Tallahassee, Florida, and Bush versus Gore, and so on and so forth. But when I was first approached about this case, and we decided that it was very, very important to bring a federal constitutional challenge to California's Proposition 8, which says that only a marriage between a man and woman will be recognized and valid in California. When we, with the help of Rob Reiner and Norman Lear and Michelle Reiner and other people, decided that this case was going to be brought by somebody in the United States in a federal court, and it was probably going to be a case that would come to the United States Supreme Court, that was exceedingly important that it be brought properly with the right foundation, with the right lawyers and the right team of people at the beginning. And I was recruited to participate in this case, and I was very, very happy to do that. But I knew that the reaction from some people would be, what is this right-wing person doing on this side of gay marriage, and who is he, and is he going to be suspect? And it would be more about me than about the case. I thought it was exceedingly important to recruit the best lawyer in America, the best lawyer in America, period. That's David Boies, but also someone identified with the other side of the political spectrum, so that people would see this case through the lens of individuals representing human beings in a civil rights crusade, and a coming together of Democrat and Republican, conservative and liberal, to speak for the American people that are being disadvantaged by Proposition 8. And so that it was important to have this message that it is a case about decency and equality and fairness. And so I suggested David Boies in a conference call that we had one Saturday, and everybody on the telephone said, "Oh my God, would he do it? That would be so fantastic." We decided to call David. I called David. David was in the midst of a meeting and depositions and a trial and everything else, that David does all these things at the same time. And I got halfway through the question, "David, would you be interested in joining up with me to fight the constitutionality of Proposition 8 in California?" And I don't think I got the words California out, and David said, "Yes." So that's how it got started.
That's great. All right, David, so Ted made the first move. What's it been like to work with him? And to work with your former opponent? Has it changed your views about him, and what is this bipartisan partnership been like?
It hasn't really changed my views about him. It has reinforced my views that I'd rather be on the same side than against him. Ted and I, although we were on different sides in Bush v. Gore, have been good friends for a long time. Ted and his wife Lady and my wife Mary and I go on bike trips together, and we've had a close social relationship. And this was a great opportunity to work together on the same case, and particularly a case of this importance, because I think that one of the messages that I hope that Ted and my participation in this case sends is that this is not a conservative or liberal issue. It's not a Republican or Democratic issue. This is a human rights issue. This is a civil rights issue. This is a constitutional issue. This is something that everybody, whether you're a conservative or a liberal, ought to have the same view on. Nobody in this country ought to be in favor of discrimination. And I think that the combining of our two backgrounds, I think helps to send that message. I also think that one of the great pleasures that you can have is working with somebody who you enjoy being with, who you like, who you admire, and working together on a case that's you think, and I believe, is one of the most important issues that we face. This is the only area in this country in which we still have state-sponsored discrimination. There are many areas in which we have a long ways to go in terms of eliminating the remnants of past discrimination. social discrimination continues to exist against many, many groups in our society. But this is the only area in which the government directly discriminates against a group of its citizens. And I think it is critically important, not only to the people who are discriminated against, but to the entire country, that we end that state-sponsored discrimination.
Very well said. We've been asked to discuss who should make this decision. Should it be the people of California? Should it be the California court? Should it be the U.S. Supreme Courts?
Okay.
So I thought it might be useful just briefly to remember how this case came about. So here are a couple key dates. 2000, 61% of California voters approve a ballot initiative, Prop 22, saying marriage has to be between a man and a woman. 2007, Governor Schwarzenegger vetoes a bill, the same-sex marriage bill, and says that this issue should be decided by the courts. May 2008, the California Supreme Court says that the right to marriage is a fundamental constitutional right that should be extended to gays and lesbians, as well as men and women, as well as straight people. And then just a few months later, in November of the same year, California voters overturned this California Supreme Court decision and passed Proposition 8 with 52% of the vote. And in May 2009, the California Supreme Court upholds this, and that same month, both of you file a suit in federal court saying that this violates a fundamental federal constitutional right. You've had this remarkable trial. It just ended in June. I've read the transcript. I urge all of you to as well. Ted's closing argument is one of the most inspiring moments in American legal history, and David's cross-examination of the opposition witnesses is this remarkable, terrifying thing to behold. It makes me very glad I'm not on the other side. David, tell me, how is it possible that the opposition was prepared to introduce all of these witnesses, and you so destroyed them that they ended up withdrawing all but one, and even he came over to your side?
Well, they start out with 6, and after depositions, they withdrew 4 of them. So they brought 2 to trial, and they really set them up, and they really set me up, because what they did was they put them on the witness stand to testify to propositions as to which there simply was no evidentiary support. They set up there to try to say that allowing gays and lesbians to marry wasn't really necessary, didn't really help them, they could have civil unions, and besides it would terribly undermine heterosexual marriage. And one of the problems is that there actually have been a fair number of studies of these issues in states where gay and lesbian marriage is permitted, in other countries, Canada, Spain, Sweden, South Africa, a lot of countries where you have same-sex marriage. And there was no support for their testimony. And they were all people who made a living by going around the country giving speeches about how bad gay and lesbian marriages were. But in those speeches, nobody got to cross-examine them. And maybe there'd be a question, but there wouldn't be any follow-up. And the witness stand in a court is a very lonely place to lie. There is no place to go. You're up there by yourself, and you stay there as long as the examiner wants you to stay there, and you answer every question the examiner asks unless the judge intervenes to help. And the judge quite quickly saw with their witnesses that they were trying to be evasive. And like a good trial judge, he tried to herd them back to the questions. And so they were confronted with really simple questions, like, do you think marriage is important? Now, what are they going to say? No? I mean, after all, they're trying to defend, quote, traditional marriage. Of course they have to say marriage is important. Do you think marriage helps children who are being raised? Do you think that it hurts people not to be married? If they want to get married, does that cause them disadvantages? They admitted on the witness stand, each element of our case, that preventing gays and lesbians from marrying hurt them in serious social, psychological, and economic ways. That preventing gay and lesbian couples from marrying hurt the children that they were raising, and hundreds of thousands of children are being raised today by gay and lesbian couples in the United States. And finally, there was simply no evidence that allowing gays and lesbians to marry could in any way harm heterosexual marriage. Now, you think that's a matter of common sense. You think a couple kids want to get married, boy and a girl. They're not going to be dissuaded from that by the fact that their neighbors down the street who happen to be gay or lesbians are getting married. People may get divorced, but it's rarely because they found out that a gay couple or a lesbian couple got married. So common sense sort of said this was kind of ridiculous. But actually, as it happens in academic life, they actually do studies of things that are common sense, and the studies uniformly showed that there was no harm. And the key witness that they had, a guy named Mr. Blankenhorn, once he began to retreat, he lost more and more confidence, and I think became more and more uncomfortable as we were able to demonstrate the fact that there wasn't any support for what he was saying. And in the end, there was a question and answer that talked about, isn't America about equality? Don't we want equality for all of our citizens? I mean, these are questions it's hard to answer no to. Isn't it a lack of equality when we say gays and lesbians can't get married? He had to agree to that. And finally, wouldn't America fit the American ideal better the day America allows gays and lesbians to marry? And he said yes. And it was a difficult moment, I think, for our opposing counsel, but it was one that was, in some senses, almost predictable. Once you start down the road of forcing people to confront what's really at issue here, it's easy to have a bumper sticker, a slogan that says marriage between a man and a woman. But when you begin to think about the issues, you think about the harm that it causes, you think about the gains that allowing people who are in love to marry the person that they love and not forcing them to marry somebody that they don't love and aren't attracted to. When you think about the harm that's done to the children, when you think about the lack of any redeeming social desires that this kind of ban has, it is inevitable that a rational person on the stand, faced with those kind of questions, is going to admit that. And I just wish we could have televised that trial, because I wish that everybody who opposes gay and lesbian marriage could have seen those questions and answers and could have thought to themselves, how would I have answered those questions?
I want to add something. This was really important. You started off with talking about Brown versus Board of Education. This was our opponents didn't want a trial. The judge said we had asked for early relief to let people proceed to get married because we contended that Proposition 8 was unconstitutional. The judge said, no, I want a trial. I want to hear witnesses talk about what marriage means in society, what discrimination has done to people in this country. I want to hear from people that talk about the effects of discrimination, lawful state-sanctioned discrimination, the thing that David was talking about. I want to hear actual evidence on all of these questions, and our opponents fought ferociously to prevent a trial, and they kept screaming to the public and the press that this is the judges showboating or doing something really kind of un-American to have a trial, for God's sake. You know, to test the truth in the crucible of the courtroom, which is really the major civil rights battles in this country have started and ended in trials. They end in the Supreme Court, but they start in trials. So this judge was a very, very wise man, and he said, we're going to have a trial. I'll do it fast because I know that you represent people who feel very strongly that their civil rights are being denied, but I'm going to have a trial, and I'm giving you this opportunity to have all these witnesses. So we leapt at that opportunity. We developed an array of 8 witnesses from as far away as Cambridge and UCLA and Harvard and Yale and Columbia and all across the country, the finest experts in the world who testified at the trial and made themselves available to cross-examination by our opponents. And they had these 6 witnesses, which, after David had deposed them during their deposition phase of this thing, 4 of them were withdrawn, and then David did this. But the point was we were trying to get at the truth of the impact of taking away the fundamental right to marry from a segment of our society, how that fits in with discrimination historically in this country, government-sponsored discrimination, what that harm that does to individuals. So David, the two things that was going on, one, they didn't have anything good to say. That was revealed by the trial. And then David, to watch David it's absolutely fabulous to see someone patiently and meticulously take apart properly and politely, but persistently, and it is a scary thing to watch unless you're on his side. But David really, we haven't got a decision in this case yet, so we don't want to get ahead of ourselves. But I thought it was an exemplar of what a trial in America means, what our American independent system of the judiciary and exposing the contentions of people to the crucible of cross-examination and the truth. That's what America is about, and that's what was revealed during that process of cross-examination.
That's great. So you're working together. Thanks to David, you shoot down most of the arguments the proponents made, that it'll discourage straight marriage, that it's bad for children. The proponents are left with this one argument that the point of marriage is to encourage procreation and discourage irresponsible procreation. And Ted, you made some very powerful points in your closing arguments about how whatever the problem with gay marriage is, it's not like there's a lot of irresponsible procreation that it's encouraging.
I'm still intrigued by the irresponsible procreation. I don't know whether that's not using condoms or what that is, but it was interesting. During the many of you are Californians, so many of you were in California during the Proposition 8 contest. The big issue that they put before the Californian people was protect our children from being taught in schools that gay marriage was acceptable. What the message there is, gay marriage isn't acceptable. We don't want our children to know about it because gay people or same-sex people, gay and lesbian people they are unacceptable. So we don't want their existence to be thought of as okay. And that is a message of stigma, and it's a message of discrimination, and it's a message of animus. I mean, we want to protect people from the idea that these are our citizens and our neighbors and our friends and our fellow citizens and so forth. Then when we got into the trial, they didn't want to be accused of that. So they said, we have to explain why we have to retain the institution of marriage to opposite sex couples, because marriage is created by the state for the purpose of encouraging procreation. When we said, well, really old people, can get married. People that don't want children can get married.
I resented that a little bit.
I speak for the really old people. The judge, in fact, said, gee, last week I married a couple that were in their 80s and they were not planning on having children. I responded to my mother, who's just turned 90, had just gotten married, and the family was not expecting any baby shower. The fact is, we have never tied marriage to procreation. We have never required people to prove that they are able or willing or anxious or intending to have children in order to have marriage. The Supreme Court has said again and again and again, marriage is a relationship between two individuals. It's a part of the liberty component of the Due Process Clause. Liberty, privacy, association, spirituality is between two individuals. And fundamentally, and I made this point too, is that if we decide that it's the state's right, marriage is something that will be granted to you by the state in order to encourage procreation. What if the state changes its mind and doesn't want procreation, China? Okay? Mm-hmm. So does this mean it's a state's right to with grant or withhold marriage? No, none of us would accept that. It is the right of individuals, not the right of the state of California. So that argument started to fall apart. Then they came up with this: if you allow people to marry someone of the same sex, it will cause the deinstitutionalization of marriage, which sounds really, oh my God, I mean, marriage will be deinstitutionalized. Well, Okay, well then you have to ask the question, well, what the hell are you talking about? What they mean is that marriage has always been between a man and a woman. If it suddenly becomes between a man and a man, or a woman and a woman, then it will be not the same institution, and therefore it will be institutionalized. And we said, all right, well, so what, And then they came up with these things about, well, maybe it will cause people to get divorced, people will not to get married, and we demolished all of that thanks to David. And then they came up in the closing arguments on June 16th with this, it's somehow we have to keep marriage between a man and a woman because of this threat of irresponsible procreation. People are going to run out and have children outside of the context of marriage. And I said in the closing argument, our clients aren't going to produce any irresponsibly created babies. So our clients, and so what this all meant was that they kept retreating because you have to come up with either a compelling governmental interest or a strong governmental interest or a rational basis. This is law esoterica, but they have to come up with a reason, and that what the state is trying to do advances some state objective. And we kept saying, well, tell us what it is, because we're going to blow it out of the water. And they kept retreating because we kept blowing it out of the water. And that's what was going on during this trial.
And the way the argument goes is, because we were the plaintiff, we got to go first in the argument. They then got to argue. We got 30 minutes in the bottom. And I would urge anybody who can, because it's on the website, is to get the 30 minutes of Ted's closing argument, which I think is the best closing argument I've heard in 45 years. As you said at the beginning, it was inspiration. It lays it all out. You could not listen to that argument and have any doubt about the unconstitutionality of that proposition.
All right, but let's put the case on the other side. I mean, this seemed to me like a case of really bad lawyering by the proponents of the proposition.
It was not bad lawyering. These are good lawyers. These are very good lawyers. Chuck Cooper is a first-rate lawyer. He has a first-rate law firm. They devoted a lot of attention to them. The problem here was not the lawyering. The problem here was that there simply wasn't any evidence on the other side. It doesn't make any difference how good the lawyers are. They can't manufacture evidence.
This seems to me to be the best case that can be made, and it was made in the New York Times on Saturday by my friend Jonathan Rauch, who both announced his own marriage to his partner on the op-ed page of the Times, and said, I'm a libertarian conservative. I think gay marriage is the great civil rights issue of our time, but I don't think the court should impose it now, because if they just have to come up with a rational reason for supporting a separate category of civil unions, I know a lot of people who really want gay marriage but support civil unions now, not because they hate gays and lesbians, but because they love them and they think there'll be a huge backlash if you impose it now, and that's going to hurt the cause of gay marriage. And therefore, the proposition isn't inherently biased or stigmatic, because it's possible to imagine people voting for it without hating gays and lesbians at all, and that would satisfy rational basis. I guess that's the best that the proponents could do. What do you guys think of that?
See, that is the best that they can do. And the judge
Thank you.
But
it wasn't very good.
But it's not very good. I mean, yeah.
I knew that there was the other shoe would drop.
Right.
But the judge asked us this, and there were several answers to this. David has given some brilliant answers in Philadelphia, that speech you gave in Philadelphia. We have not, in this country, waited for a poll to say that you are entitled to your constitutional rights. Brown versus Board of Education again. It takes we have a constitution because we don't submit people's fundamental constitutional rights and their right to the equal protection of the laws to a vote of the people. We put on a political science expert that says when you have referenda or initiatives or the process, that it's a very good thing in progressive movement to have these kind of things that California has and Colorado has. But minorities tend to lose those elections when you put minority rights up to a vote, and that's what happens again and again and again with this issue. I said, and I'm going to make this short because I know you want to say about this. The best thing that I ever read about this, and it moves me every time I read it, is Martin Luther King's letter from a Birmingham jail, when he's responding to people saying, go slow. People aren't ready for this. It is going to hurt us. It is going to cause a backlash. It is going to hurt our people. It's going to hurt our cause. Slow down. Wait. And he responds to that eloquently. Civil rights don't wait for people to come around. In fact, people who bring cases to vindicate people's civil rights, advance civil rights. Even if you lose a case, you keep fighting, you win a case, you lose a case, and so forth. And the very fact of this case, and that you're here listening to David and me, and David and I have had opportunities to appear on national television, we are helping, I think, to change people's opinions, because we're talking about this, and we're talking about what happened in our trial, and we're daring people listen to the evidence and dare to come to a conclusion like that. To say that, gee, I don't want you to have any rights now because people get mad at you if you're treated like the people in your neighborhood. Gee whiz, why don't you wait 10 or 15 years until this happens? There's 5 states now that permit same-sex marriage. 45 states don't. Suppose we backed away in California. When will Californians change? And California's going to be ahead of people in Arkansas and Utah and places like that. When do we tell people that you can now be treated as equal in our country? We believe, like the opposing witness conceded, that when we get to this point, people will recognize we will be more American and we will understand what's going on here. But this issue of don't do it now and judges shouldn't do it is just plain wrong and inconsistent with our Constitution. David says this better than I do.
No, I couldn't say it better than that. I think that's exactly right, and I think Martin Luther King said it better than either of us could have in that letter. I think that first, if there's going to be a backlash because a group of our citizens get the same rights that all the rest of us take for granted, that is a demonstration of why there is discrimination and that it has to be stopped. It's not a justification for saying we're not going to attack discrimination. The second thing I'd say is that if you ask gays and lesbians, do they want to have the right to get married? Overwhelmingly, they have expressed that, and they've expressed that in every forum that we've seen. There were many people in the gay and lesbian activist community who were very concerned about this suit in the beginning because they thought we would bring it and lose, not because they thought we would bring it and win. Nobody that I have heard has come forward and say, we don't want to win this issue because we're afraid people will be mad at us for getting the same rights that everybody else has. So I think that you can always argue to go slow, you can always tell people to wait, you can always tell people to be patient, but it's very hard to be one of those people who's being told, be patient, wait, don't take your rights. And I wish, again, this case could have been televised, because I wish you could have seen the testimony of our 4 plaintiffs about why they wanted to get married.
Again, there was a very moving moment, I think, and why don't you describe
Well, the very first witness that we put on the stand, I asked him, why are you bringing this lawsuit? Why do you want to get married? And his response just stopped. I get emotional. I'm thinking about it now.
That testimony of the 4 plaintiffs, we were asked them what it felt like to be denied the opportunity to get married, why they wanted to get married. They're both in the 2 couples that are in long-term relationships, 8 to 10 years. The 2 women have 4 children that they've been raising, lovely young boys.
Really nice kids.
And they, in their own words, we didn't put any words in their mouth, we just asked them to tell us what it's like to be on the outs, to be treated differently, to have to come out every day because they can't say that the person they're living with and raising a family with, they're married to. What that harm that does to them, in their own words, and I said this to the judge at the very end of our closing argument, I could not have made a better closing argument than just to allow them to speak again. The judge, this television business, the judge decided at the beginning of the trial that he wanted to have an experiment, and it's permitted by the federal rules. He wanted to allow cameras in the courtroom. He wanted this to be streamed out to people. The Supreme Court stopped it, I think, in a huge mistake. Our opponents raised all kinds of issues about witnesses being intimidated, which was just nonsense because these were professional witnesses, and well, they were worried about David Boies is what they were worried about. But the the Supreme Court doesn't like cameras in the courtroom and stopped this thing. And if there had ever been a trial that the American people deserved to see and should have seen is a constitutional case. It wasn't a criminal case. It wasn't a jury. It was a constitutional case affecting the lives of hundreds of thousands of people throughout the United States, millions of people throughout the United States, serious witnesses, people speaking from the heart. Those of us who were in the courtroom when our 4 plaintiffs testified, I don't think there was a single person in that courtroom that was not in tears. It was a very moving experience, and now we're encouraging people to take the transcript of the trial and to act it out. Get on stage, read the script, and to talk about it, because only then can you feel the emotion. Only then can you understand. People that have been in gay rights movements their whole life said, I've never seen anything like it in my life, the education that took place during that trial. If there ever was a trial that should have been televised to the American people, this is it. And then you would have felt not just the legal issues, but the emotional issues that are impacted by discrimination.
All right, gentlemen, if you win this case, as many people think you will.
David, I need more.
Yes, absolutely. See, I kept the bottle.
Yeah. How did it happen that David got the wine bottle?
Good. You keep each other honest, which is very, very good. All right, so imagine you win. The other side's going to appeal. The appellate court's going to hear it. It'll be appealed to the Supreme Court. Like most issues of our national life, it'll be all decided by Justice Anthony Kennedy, who is running the country and has expressed some very strong pro-gay rights views that might give you hope. But Justice Kennedy, like all the other Supreme Court justices, know that the court often gets into trouble when it leaps ahead of the country. And there's been a big discussion about this recently. We saw it in the Kagan hearings. Brown versus Board of Education is actually decided at a time when 54% of the country supports desegregation. It was not a minority view. The interracial marriage case is then appealed, and the court won't hear it for more than 15 years until they think the country's ready for it, and only 15 states ban interracial marriage. It's different now. As you said, 45 states ban gay marriage. Every time there's been a pro-gay marriage decision, it's been often overturned by state constitutional amendments. It's provoked these backlashes. And I looked at the latest polls. I know you're not supposed to cite them, but the justices read them like everyone else. 47% of the country right now supports gay marriage, not a majority. In 5 years, it'll be a majority. In 10 years, there will be gay marriage, politically. Will Anthony Kennedy really want to be the justice who right now, before the whole country has crystallized around this issue, leaps ahead and imposes a view that a majority of the country may reject?
Let me give you 3 answers. First, keep in mind that when the United States Supreme Court banned state laws forbidding interracial marriage, 70% of the country...
This is a case called Loving versus Virginia in 1967.
Right. And as Ted has pointed out many times, in the absence of that ruling, Barack Obama's parents could not have gotten married in 15 states at the time they got married.
It would have been a felony.
It would be a felony. And 70% of the American people opposed interracial marriage at the time that that decision was announced. The second thing is that if you don't have a constitution that is prepared to be enforced, you don't have a constitution at all. You don't need a constitution if you've got a majority of people in favor of something, because the legislature can vote it. The people can vote it. You only need a constitution when you've got to protect minority rights against a majority. The third answer is that Ted and I have a deal. I'm going to get the 4 justices I got in Bush v. Gore. He's going to get the 5 justices he got in Bush v. Gore. And we're going to have a unanimous decision.
Ted, I want your answer, because
I've still got my 5. You're going to have to. You're going to have to.
That's
convert,
right. I've got to
You're going to have to convert
two,
2
right.
of them. You know, but I think you can do it.
Ted, you've spent your career denouncing judicial activism, and you're no fan of Roe v. Wade. You say the court leapt ahead and it was too soon, and it was legislating from the bench. What's different about
I
this?
never said anything about Roe versus Wade, so I don't know where you got that. But what I'll say, people do raise Roe versus Wade and judicial activism and things like that. But judicial activism is the person who doesn't like the outcome of the latest case that came down from the Supreme Court over and over again. Both sides equally wrong about this. The Supreme Court of the United States, we're not talking about inventing a new right. In 1888, the first time the Supreme Court said there was a fundamental right of individuals to marry. I counted, by the time of our closing argument 3 weeks ago, I counted 14 cases in which the Supreme Court of the United States said that there was a fundamental right of individuals to get married, and in the context of interracial marriage, in the context of contraception, in the context of getting a divorce, in the context of abortion, in the context of prisoners getting married, and in various other contexts. The Supreme Court has said it is a matter of liberty, it's a matter of privacy, it's a matter of association, it's a matter of spirituality, it's a matter of self-identification. That's Justice Kennedy saying those things. And in the case, I'll mention in a second, of individuals who are homosexuals, the fundamental right to marriage was mentioned. We are reaffirmed. So we're not talking about a new right. We're talking about a fundamental right that the Supreme Court 14 times in the last 130 some years has said is a fundamental right of all Americans. And after the Loving case, the interracial marriage case, someone in the next case that came along said, well, that had to do with interracial marriages. That the Supreme Court, in the words of Justice O'Connor, said, no, that had to do with all individuals, not interracial marriages. So we're talking about the right of privacy and liberty and identification with one another. In the Loving case, which is the interracial marriage case, the Supreme Court said you had the right in Virginia to marry anyone you wanted unless it was the person of the wrong race. And the argument was, well, it applies to black people and white people. You still have to marry someone of the same race. It's not a discrimination. Okay, so now in California, you have the right to marry anybody you want unless it's the person of the wrong sex. And the same arguments are being made that the institution of marriage is going to be devalued and destroyed and so forth if we allow marriages to take place in this context. It isn't the case. And coming back to Justice Kennedy, we're taking no justice for granted, and we're taking no justice as beyond our ability to persuade them. As David says, he's got a big responsibility, but he's going to get those 4 justices. But this is serious. Justice Kennedy wrote the opinion for the United States Supreme Court. It was a 6-3 decision. The state of Colorado, where we are now, the voters went to the polls and passed a constitutional amendment to the Colorado Constitution, wiping out all municipal and state laws that prohibited discrimination on the basis of sexual orientation. It was aimed at gays and lesbians. The United States Supreme Court struck that down as unconstitutional. Then a few years later, and that Justice Kennedy wrote that opinion, a few years later in a case called Lawrence versus Texas, Texas laws that prohibited intimate sexual conduct between individuals of the same sex was struck down as unconstitutional because it invaded the right of individuals in their zone of privacy. That case was written by Justice Kennedy as well. And again, it was a 6-3 decision. Now, we're not anticipating anything. We're going to make the best arguments we possibly can, and we don't want to pick out any particular justice. But we've thought this over very carefully. We don't think this is judicial activism. We think this is equality, and we think it's due process. We think we have ample precedent to support our position.
This is my last question, and then I'm going to open it up to the audience. We know the justices do think politically. We know because we read the transcripts of how they decided to wait for 15 years before hearing that interracial marriage case. And Felix Frankfurter kept saying, the country's not ready. It'll destroy the court. The court's legitimacy is going to be imperiled. Wait. Do you think there will be some justices who might fear the political consequences, thinking this is the worst thing that could happen for President Obama, for the Democrats, for the gay rights movement? Better to wait 5 years when the country's ready And based on those considerations, do you in fact think the Supreme Court's going to vote to hear the
No,
case?
I will just say this, it's very, very important. When Loving versus Virginia, that's only 40 years ago, 1967. It's unthinkable that you said the court waited 15 years. The California Supreme Court was the first one to strike down bans on interracial marriages. Other courts came along, 15 states were still left, and as David said, it was a large popular opinion. It was wrong for people of different races to get married. Would have prevented our president, would have been a felony for our president's parents to get married in Virginia and 14 other states. Today, I don't know of anybody that thinks that was a remarkable decision. People say, you mean just 40 years ago, we didn't let people of a different background get married? It was not much more than 50 years ago that we put people of different races in segregated schools.